We will go on the record in the matter 23 CT97 and 24 CT30, State of Wisconsin versus Ethan Java. The state appears through District Attorney Kevin Schmidt in person. Mr. Java appears in person with counsel Joel Feliski. We're set today in this matter for a plea and sentencing. The parties have reached an agreement, the global resolution. Mr. Feliski, can you please update the court?
Absolutely, Your Honor. As you stated, Your Honor, the parties have managed to reach an agreement in this matter. I'll state that agreement for the record. Mr. Java has agreed to plead to OWI 2 and 3, the remaining counts in 24 CT30 and 23 CT97 dismissed and read in. The parties will be making a joint recommendation of sentencing under Burnett County IDIP guidelines with an added condition of 1 year probation. The conditions of probation will include an AODA assessment as well as the completion of a driver safety plan. I have a completed plea questionnaire and waiver of rights form. Your Honor, may I approach?
You may. So with regards to the jail with that, it would be the OWI second 5 days and then OWI third would be, is a BAC of 0.204. So that would be 55 days of jail. Is that correct?
I believe so, Your Honor.
All right, thank you. What is his jail credit?
Your Honor, he appears to have 60 days total jail credit. He was in custody on 4/11/24, released on 4/16/24, arrested again on 8/5/24, then released on 8/7/2024, and then lastly has been in custody as of today since April 27th of 2025.
All right, thank you. So Mr. Java, that is correct. That's the agreement you've reached with the state?
Yes.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yep.
Did your attorney go over this document with you thoroughly,
Yes, he did.
essentially word for word?
Yep.
And you understand everything on this document?
Yes,
And that is your signature on the second page?
it is.
You're pleading guilty to 1 count of OWI second and 1 count of OWI third. You're 31 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, it is.
No mental illnesses or disorders, and no drugs, alcohol, or other medications in the last 24 hours.
Nope.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt for those 2 counts?
Yes.
Did your attorney go over with you the minimum as well as the maximum possible penalty for those 2 counts?
He did.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. Your attorney thoroughly went over those rights with you,
Yes.
and you understand them completely?
Yep.
Do you need me to go over those rights with you in any more detail?
I do not.
Do you understand that by pleading guilty to these 2 counts, that you are waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yep.
Do you understand that with regards to the OWI second, the state would have to prove on or around December 2nd, 2023 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, which is a misdemeanor, and it would be your second countable offense. Do you understand what the state would have to prove?
Yep.
Do you understand that upon conviction, you face a fine of not less than $350, but no more than $1,100, and imprisonment for not less than 5 days, but no more than 6 months? Do you understand that?
Yes.
And do you understand that the court shall revoke your driving privileges for not less than 1 year, but no more than 18 months, and shall order you to submit to an AODA OWI assessment and follow through?
Yes.
Do you understand with regards to the OWI third offense, the state would have to prove on or around February 14, 2024 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, again, a misdemeanor, which would be your third countable offense? Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty for this offense could be a fine of not less than $350, but no more than $2,000 and imprisonment of not less than 45 days, but no more than 1 year in prison. Do you understand that?
Yes.
And do you understand that with regards, and I would also have to order those same restrictions with your driver's license, revocation, ignition interlock device, and OWI assessment and follow through?
Yep.
Do you understand that there is an agreement here for the court to follow the IDIP guidelines, which are the mandatory minimums with regards to these offenses? Do you understand? I'm not bound to follow that. You understand that?
Yes, I understand.
And said differently, I could sentence you to the maximum possible penalty for both of these crimes, and I could have them be either a concurrent or a consecutive sentence. Do you understand that?
Yes, I understand.
Do you still wish to proceed and enter guilty pleas?
Yes, I do.
Did you go over the criminal complaints with your attorney, those initial charging documents that basically say what happened and why you were charged with the crimes?
Yes,
For the most part, are those facts accurate?
they are.
Are you admitting here today that you did in fact on December 2nd, 2023, operate a motor vehicle while under the influence of an intoxicant?
Yes,
And are you admitting to the court here today that on February 14th, 2024, that you in fact did operate a motor vehicle while under the influence of an intoxicant?
yes.
And you are pleading guilty because you're guilty of both of these offenses?
Mhm.
Is that yes?
Yes,
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to these two charges?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing today
yes,
and voluntarily.
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at both of these matters thoroughly?
yes.
Has he looked to see if you have any defenses or a lack of defenses in this case?
I believe so.
And he looked at the discovery and the evidence and he discussed that with you?
Yep,
And you shared all of the information that you know to exist about these cases?
yes,
Are you satisfied with his services?
yeah.
Do you have any questions for the court or for your attorney before I proceed?
I do not.
As to 23 CT 97, OWI second, how do you wish to plead?
I plead guilty.
As to 24 CT 30, OWI third, how do you wish to plead?
I plead guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of an OWI second charge and an OWI third charge. Count 2 in 23 CT 97, as well as count 2 in 24 CT 30 will be dismissed and merged in with the count 1s. A judgment of conviction will be entered today. Formal motion to amend 24 CT 30 to an OWI third.
So made. So made.
Granted. Argument and sentencing recommendation, Mr. Schmidt.
Yeah, thank you, Judge. Mr. Java has no prior criminal convictions. His OWI that formed the basis for these being a 2 and a 3, that occurred in 2016. These two OWIs occurred in December of 23 and February of 24, making them very close together temporarily in terms of time. He cannot complete the IDIP program right now because he's in jail and he can't post bond. So we're doing the IDIP guidelines because we're doing the probation, and probation's not typical in 2 and 3. That should get us the AODA that we normally get through IDIP. That's why the state's arguing he should get that benefit there. He's also upfront sat the jail of this with the time he spent in custody as a result of his missed court. He's also suffered the consequence of forfeiting a significant amount of cash from his missed court appearances and defaulted on over $1,500 worth of traffic tickets already. So I think Mr. Java's already suffered a pretty significant punishment now. Studies show us celerity of punishment to the time of the offense increases the effect of the punishment. So the fact that it's being front loaded is positive for terms of rehabilitation and punishment of the offender. So for those reasons, we'd ask the court to follow the agreement. Thank you.
All right, thank you, Mr. Felisky.
Thank you. Thank you, Your Honor. I concur with the statements made by the state. I would add that since the beginning, I've been representing Mr. Java. He has wanted to resolve this matter. He's taking accountability. He understands what he did wasn't acceptable and that he needs to change his behavior and not commit these types of acts again. He has already, even before I represented him, reached out to his brother in River Falls. He's set up a place for him to land at, to stay while he gets his life together after he gets out of custody. One of the very first things he's going to be doing after he gets out of custody, besides getting in contact with probation, is looking for work. Part of why he's going to River Falls is because that's a larger town, so he will have better access to public transportation, the ability to get around so that he can get back to work and can get his life back together. He's taking accountability for his actions here today. He's willing and ready to move forward. I think this agreement protects the community. I think it's appropriate given the nature of the offenses here. And I believe that Mr. Java going on probation will address his rehabilitative needs, excuse me. For those reasons, I would ask the court to follow the agreement. Thank you.
Thank you. Mr. Java, do you care to make a statement here today? You don't have to, but it's your only opportunity to let me know anything you want me to know about these two cases, the underlying facts, what's going on, anything that you think would be helpful.
I guess at the time that happened, I was kind of going through a lot, and I don't want to use it as an excuse, but I had lost a friend at the time and it hurt and I didn't handle it very well. So,
Lost a friend as in they passed away?
Yep.
I'm very sorry.
yep, they got in a motorcycle accident and it really hit home. And then that's kind of why I spun out of control there. So,
Well, I appreciate that, Mr. Java, because I was going to say it does appear that something was going on around that time. Granted, you've had an OWI before, but it was ways before these two. And to get one right after another, something has to.
yeah, I wasn't doing very good. I've moved past that. I mean, obviously I'm still sad that my friend's gone and whatnot, but everything is kind of straightening out and trying to move forward.
All right, I do appreciate that. When a court looks at sentencing, first I have to look at how serious are the offenses. Then I have to look at the defendant, any needs for rehabilitation, your age, factors such as losing your friend and having to go through that trauma. And I also have to look at needing to protect the public. When we're looking at OWIs, we all know they're very serious. I don't know what happened to your friend. I'm pretty sure I probably know who it was, but I don't know the underlying facts or if alcohol was involved. But you know that drinking alcoholic beverages and driving while under the influence and being intoxicated puts everybody at risk. You could have lost your life. Somebody else could have lost their life or been seriously impaired or critically injured. They are very serious. And then one right after another aggravates it. It indicates that there was something going on. You needed some help, some services, and you needed to address some issues. So it does look like you have some rehabilitative needs, perhaps some AODA and some counseling with that, and counseling emotionally with what you are going through with the loss of your friend. You're never going to get over it. It's not something you get over. You just learn how to live with it and move forward and remember the good times, even though it hurts to think of the loss of your friend. So I do think probation would be appropriate, especially in this type of case. Needing to protect the public is kind of with the whole serious crime, because OWIs are serious and the court needs to look at protecting the public to ensure that not only are you learning from this and you won't do it again, but others are learning from this and they won't do it as well, and that the public is safe. In looking at these cases, I do think the recommendation is appropriate. It meets the needs of both the state as well as your needs and the community. With regards to 23 CT97, the court is going to order 5 days of jail, $976 in fines and fees, plus a $10 blood draw fee, 1 year of ignition interlock device, as well as 1 year of revocation of your driver's license. With regards to 24 CT 30, the OWI third, the court is going to order $3,175 in fines and fees, plus again, a $10 blood draw fee, 55 days of jail, 24 months of ignition interlock device, as well as revocation of your driver's license, and they will be consecutive to each other. The court is also going to order 1 year of probation with the 24 CT case. And I am going to put certain conditions on that, an AODA assessment, OWI assessment, and follow through, driver safety plan. I am going to order that part of your condition will also include getting your driver's license, even if it's an occupational license within that year time. Testing upon reasonable notice, arrest or agent's discretion, gainful employment and or additional schooling to work towards something like, even if you're going to do like a certificate class or something to improve yourself in finding a job, that is also what the court will order. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no bars, taverns, liquor stores, establishments that have the primary purpose for the sale or the service of alcohol, and no casinos. The court is ordering your DNA. You must provide that to the jail before you can be released. You have the right to request it be expunged through a written letter to the Department of Justice, not to this court, but to the Department of Justice. You have 5 days of credit for your 23 case and 55 days of, would it be 55 days of credit for your 24 case? If you fail to pay your fines and fees, not only will the court enter a civil judgment against you because you're always going to owe it, but you could sit up to an additional 6 months in jail, and the court will issue a warrant if you fail to make your monthly payment. What I'm going to do is order $200 a month to be paid towards your fines and fees. We will collect it here in Burnett County, not probation. You will send your payments directly to the clerk's office so that we can monitor that. I believe that covers everything. Mr. Schmidt, what am I missing?
Nothing from me.
Nothing further. Thank you.
All right, Mr. Java, what you need to do as soon as you're released from custody is you're going to need to go over to probation in Burnett County, get that set up. If you're going to be moving to River Falls with your brother, you're going to need to tell them that, and they can transfer probation to the River Falls. Okay. All right. So immediately when you're released, go to probation. Let me verify your telephone and address, at least at this time. Is it still 7617 County Road B?
Yep, that's my dad's.
And 4078 for your last 4 of your telephone.
I don't actually have a telephone right now, but.
But you're gonna get one?
Yep.
Once you do, please make sure that this court is updated and probation is updated to that new number, okay?
Okay.
All right, thank you. Then we are adjourned.